Hello everyone, welcome to Linda Liu IP course. Today I'd like to introduce you two important doctrines in China's patent litigation: Estoppel and disclosure dedication. In China, the Estoppel doctrine is not provided in the patent law. However, in the judicial interpretations of the Supreme People's Court (SPC) about hearing the patent infringement litigation, the Estoppel doctrine has been stipulated many times. The judicial interpretation stipulates that where patent applicants or patentees have abandoned technical solutions through amendments to claims, descriptions, or through statements or opinions, responses in the patent granting or invalidation procedures, the patentees include them in patent infringement disputes, the People's Court shall not support. The judicial interpretation also stipulates that the court may use other patents that have a divisional application relationship with the asserted patent, their patent file wrappers, and their effective patent granting and post-granting decisions to construe the claims of the asserted patent. Patent file wrapper includes written responses submitted by patent applicants or patentees during the patent prosecution or post-granting proceedings, office actions and effective decisions issued by the CNIPA and its Patent Re-examination and Invalidation Department (PRED), meeting records, oral hearing records, etc. When determining whether to grant a patent right, whether the patent right is valid, and whether it constitutes a patent infringement, the patent applicant or patentee's interpretation of the technical features in its claims should be consistent. The applicants or patentees are not allowed to make narrow interpretations of claims in the process of a patent prosecution and invalidation procedure in order to obtain patent rights or maintain the validity of the patent, and then make broad interpretations of claims in the litigation in order to prove the infringement. In patent infringement litigation, the patentee should be prohibited from reincorporating the explicitly abandoned technical solution into the scope of patent protection. The core concept of the Estoppel doctrine is based on the principle of honesty and trustworthiness to prevent the patentee from benefiting at both ends in the prosecution and the litigation procedures, thereby protecting the public's interest. The judicial interpretation also stipulates that if the right owner proves that the applicant's or the patentee's restrictive amendment or statement to the claims, descriptions, and drawings in the patent granting and post-granting proceedings are explicitly denied, the People's Court shall affirm the amendment or statement did not lead to the abandonment of the technical solution. The application of the Estoppel doctrine has been reflected in many judicial proceedings in China. For example, in the infringement case of DeepQuan AI Technologies, DeepQuan, and Jiugong Audio Mixing Company Jiugong versus Beijing Sogo Technology Sogo, concluded by the SPC in 2019, the court held that the assertion of DeepQuan and Jiugong that the technical features D contain the situation of a partly display is to include the technical solution abandoned in the patent prosecution into the scope of patent protection, which is contrary to the Estoppel doctrine stipulated in the judicial interpretation, and thus the court does not approve it. The court did not support the patentee's assertion. In summary, there are three conditions for application of the Estoppel doctrine in China. 1. The patentee has abandoned one or several specific technical features in the patent granting or post-granting procedure. 2. The technical features abandoned by the patentee in the patent granting or post-granting procedure are those that constitute the same or equivalent technical features to the alleged infringing product in the infringement litigation. 3. The restriction or abandonment of technical features made by the patentee has not been explicitly denied and has been recorded in the patent file wrapper, for example, recorded in the responses to the office action. It's worth noting that Estoppel doctrine is also applicable in the invalidation procedure after granting. That is, in the invalidation stage, the interpretations of patentee should be consistent with those in the prosecution stage. Therefore, the applicant must consider the influence of the Estoppel doctrine on the subsequent procedure when making responses or amendments during patent prosecution. Next, let's talk about the disclosure dedication doctrine, which is also known as donation doctrine. When construing the patent claims to determine patent infringement in China, the principle of equivalence will be applied. That is, the protection scope of a patent right is not only determined by the technical features recorded in the claims, but may also be determined by equivalent features. Therefore, the protection scope may be wider than the scope of the written claims when determining the protection scope of the claims in China. For the purpose of protecting the patent right and maintaining the publicity and credibility of the claims, as well as balancing the interests of the patentee and the public, it's necessary to properly restrict the application of the principle of equivalence, so as to prevent the inappropriate expansion of the protection scope of the patent right. In addition to the Estoppel doctrine, China also applies the disclosure dedication doctrine. According to relevant judicial interpretations, for technical solutions that are only described in the description or drawings, but not recorded in claims, the People's Court shall not support the inclusion of the technical solutions in the scope of patent protection by the right holders in the patent infringement dispute case. Accordingly, if the patentee discloses a certain solution in the patent specification, but does not include it or attempts to include it in the claims of the patent application during the prosecution stage, the solution is deemed to be donated to the public, and after the patent application is granted, the patentee shall not attempt to reincorporate it into the protection scope of the claims through the principle of equivalence when enforcing the patent right. The application of the disclosure dedication doctrine has been found in many judicial precedents in China. For example, in the SPC retrial case of Zhejiang Lexuer vs. Chen Shundi, the patent in dispute involves a method of making a hot water bag. The judges believe that the exchange of step 10 and 11 has indeed produced the technical effects of simplifying procedures, saving time, and improving efficiency as claimed by Zhejiang Lexuer. As a result, the replaced steps do not have the equivalent technical features to step 10 and 11 of claim 1 in the patent in dispute. The description of the patent in dispute clearly states that step 10 and 11 can be exchanged, but is not included in the claims. So, during the litigation, the exchange steps cannot be included in the protection scope of the patent in dispute. Zhejiang Lexuer's claim that the disclosure dedication doctrine should be applied to steps 10 and 11 is supported by the SPC. Therefore, the SPC ruled that Zhejiang Lexuer's producing method does not infringe the patent rights in dispute. There are substantially two reasons for the patentee to make technical solution dedication. One is negligence, and the other is to make it easier for the patent application to be granted by claiming a smaller scope of protection. But in either case, the patentee should bear the legal consequences of the disclosure dedication doctrine. Thus, when drafting the patent, it's necessary to incorporate all possible technical solutions into the scope of protection. So, in order to obtain a useful patent weapon, you need to pay attention from the drafting stage. First, we should use precise wording as much as possible, highlight the innovation points that needs to be protected, and establish the widest possible scope of protection. Second, when drafting the patent applications, the drafters often refer to the specific product design and are limited by it. But the experienced patent drafters will consciously overcome the influence of the specific product design so as to take into account various possible design ideas and form the largest possible scope of patent protection. Last but not least, we should pay special attention when narrowing the claims in the prosecution stage, not to abandon the valuable protection scope. That's it for today's IP course. Hope you find it helpful. I'm Peter Zhang. See you next time.